Hello, everybody, and thanks for joining another one of our webinars. I'll start by giving the obvious disclaimer. The information we're giving you today is not intended to be legal advice. It's really important information, and we encourage you to discuss this with your privacy teams and your legal teams as you're thinking about how you're going to be building out your ability to handle employee subject requests. So let's get to the meat of it. So what are we going to talk about today? We'll give you the basics on, one, who needs to comply with CPRA and specifically the employee requests, what types of employee and B2B data are covered now, what companies should be thinking about as they're accepting and processing requests. What are the differences about what are the differences about fulfilling employee requests versus consumer requests? And then give you a shopping list of things that you should be starting to do or get prepared if you're not already in motion on doing that. Maybe some lessons learned from our friends across the pond. As we think about CPRA, again, if you've attended any of our webinars on CPRA in general, these next few slides are the primer to the course. You've heard this before. CPRA applies to companies that have an annual gross revenue of $25 million a year, that annually buy, sell, receive, or share personal information from at least 100,000 consumers, households, or devices. And you'll hear this repeatedly throughout the presentation. Consumers now include employees, and that companies that make over 50% of their gross revenue from selling or now under CPRA sharing personal information. Again, very high overview of CPRA. CPRA goes into effect this coming January 1. And it introduces a number of things beyond what CCPA had originally asked us to do. One, it focuses on data and the reasonable and proportionate collection and use of data. So this all ties into how much data you're collecting, having a real important reason to use it, having it be highly useful and beneficial to the reason why you're using it, and then to be able to collect and get consent where necessary for that data. CPRA also talks about enhanced notices on your privacy pages and at your points of collection. It talks about the need for assessments for risky behavior and for sharing data with third parties and service providers. It talks further about contracting your service providers and subcontractors so that they too are obligated to uphold the CPRA when processing CA data. And they've expanded the rights under CPRA to include a few new things, particularly correction. The big topic about the CPRA and what we're here to talk about today is that under CPRA, there was an exemption for employee HR business-to-business data. That extension, that exemption was not extended at the end of this year's legislature. And as a result of that, when CPRA goes into effect, employee data is now in play. And so if you have employees or subcontractors or contractors in California, this will be important for you to know and understand. And so effective January 1, employers will have to honor privacy rights for consumer and employee and business data. And that in general terms means, your employees, your job applicants, independent contractors, and subcontractors. And I'll pause there for just a moment. If there are any questions, I again encourage you to put them in the Q&A, and Sheridan and I will field them as best possible. So let's talk a little bit about the types of employees and B2B data that are covered. Personal information of job applicants, employees, owners, directors, officers, independent contractors, all in the context of employment or job applications are in scope. So, generally speaking, anybody that is a business-to-business relationship with you, whether it's an employee or somebody that you hire to do work for you, is in scope. Personal information reflecting written and verbal communications or a transaction where the consumer is acting in a business-to-business commercial transaction is in scope. So all information that's written or recorded potentially is information that's discoverable and accessible when people are asking for their subject rights as an employee. What's interesting, and what many of you are probably aware of, is that prior to CCPA or CPRA, the state of California already has a series of employment rights that speak to HR data. And currently in California, employees have the right to access their payroll records, their employment agreements, and their personnel files. They have the right to correct their data, and they have the right not to be discriminated against if, for example, they refute the data or have further issues with the data. And so it's important to think about that already because as we think now about CPRA, CPRA is calling out specific rights now that employees have as consumers in California. And again, they have the right to access their data. They have the right to consent to certain types of uses of their data. They have the right for non-discrimination or equality. They have the right to delete or and correct their data. And they have the right of portability to be able to collect their data in an easily readable format. Under CPRA, they have now the right for correction, the right to opt out of automated decision-making, the right to be informed about the data that's being used to make automated decision-making decisions, and they have the right to restrict the use of sensitive personal information. And again, the key point here is this used to apply only to what we would define traditionally as consumers, but consumers again now include your workforce data subjects as well.
Hey, Rick, we've got a couple of questions in the chat I think we can talk about here. So I think the first one is scenarios where you've got companies that are based in California, but they have employees that are remote. Just kind of specifically, who does this apply to?
So theoretically, that's a great question, and I think there still needs to be more clarity on this. And Sheridan, I'd be curious to your opinion on this as well. It applies to so CPRA applies to anybody that is doing business in California. The employee benefit here, I assume, would apply that if you are. Well, I think the bifurcation here for the employee requirement is going to be that you are a workforce member, that you are a B2B relationship, that you are an employee based in California. But I don't know if precedent has been formally set on that yet.
Correct. My understanding on that is as well as that the employee needs to be a resident, right? CPRA is written about California residents. So if they are not a resident of California, then this should not apply. Of course, the Attorney General could issue different regulations, and totally override that. But my expectation at this point would be it would be limited to California residents.
I would agree.
Do you want to opine on what the definition of an independent contractor is?
Again, a little bit more clarity needs to be given to that, but I would say that in my interpretation of that would be, people that you might hire under the definition of a consultant who might be an independent contractor. An independent contractor might be somebody that you bring in on an ad hoc basis to work on a project for you. I would say would probably be the most general terms of how I would interpret that definition.
Yep, and they specifically asked about offshore and developers who potentially are being provided on a staffing basis. Again, I think if they're not California residents, then I think they'll be out of scope for this.
Yeah, I agree.
Yeah. We have a question. If you do not meet the revenue threshold, does that mean you're completely out of these requirements?
So some of the CPRA is but I would say if you don't meet the requirements of CPRA in general, you are out of scope of this. I would say that if you don't meet the revenue requirement, that you are probably out of scope.
All right, perfect. I think there's a couple other scenario questions, but we can tackle those at the end if we have time. So,
okay, great. So I want to move on to the next slide, which is some don't apply. Okay, so just bring us back here. So we have rights that include access and consent and equality and deletion and portability, correction, etc. What's called into question right now is that some of the rights in CPRA may not apply in an employment context. The right to opt out, for example, might not be applicable here. The right to opt out of this, the right to opt out of sale sharing in particular. And the reason for that is that typically employers don't sell employee data. They don't track employees for targeted advertising. And so the whole notion of sell or sharing is probably not relevant here. And we'll look to the agency in California to give us some clarity on that. The right to limit the use of sensitive personal information probably also doesn't apply in this context, because sensitive personal information that's collected is typically only used in a human resources purpose. And again, it's only used from the point of view of, either work-related or, potentially health-related or payroll-related kinds of information. And so there's going to need to be some clarity that whether or not this data is in scope or out of scope. And based on the answer to that question is going to influence the way in which you as employers are going to respond to your access requests. There are a number of new challenges that we're going to face beyond some of the conflicts with the laws. I'm going to pass the ball back over to Sheridan now for the second half of this presentation. Sheridan, over to you.
Thanks, Rick. I'm going to try and just tackle some of these questions that are coming in before I get started here. So, So there's a question in here about personnel disciplinary notes and what do you need to disclose. We'll talk about this, I think, a little bit more in depth later, but in general, yes, you will need to be able to provide these, assuming that you can provide them without violating the rights of another individual, right? So you're going to have to spend a little bit of time reviewing these. There's definitely going to be some challenges around sorting through that. Employees in California, works in an office in California, but headquarters in a different state. Does CPRA apply? Yes, it does. As long as you meet the scope of being a covered entity, then you do need to comply. In regards to deletions, in terms of deletion requests, what you can and cannot delete is going to be a very tricky question. We're still waiting on some additional information from the California Attorney General. The hard part here is, and it ties into some of these challenges that we're going to face, but where do existing employment laws in California, end, and where does CPRA begin? Right? If you need to keep that information in order to meet another obligation, then you absolutely need to keep it, and you can't delete it. You can't do anything with it. And you would have to provide a response back to the employee stating kind of why, or the former employee, why you can't delete it, and letting them know the reason, right? So, all right.
I think you answered this question also, but there was a few questions about lawsuits and garnishments. That the same answer for that. That's going to be considered information that is going to need to be retained by the company to resolve those issues.
Yep, absolutely. All right, so there's a couple challenges around processing employee and B2B DSARs. The first big challenge is really that employee data tends to live in different spots than consumer data does. Now, there might be some commingling here, but in general, companies are going to have to be working with different teams, different systems, different departments entirely that they haven't previously brought into the fold for DSAR requests. And so there's going to be a lot of training, first of all. Probably need to build some new processes and workflows. And that's going to, people should start doing this now, right? Because that's not an easy process to get uplifted. Information outside of CPRA scope may be exposed. This is a big one, right? As you're pulling up some of that information about employees, there's a lot of data that we collect about them that you may not be able to, right? And as you're sorting through things like emails, Word documents and stuff like that that might be attached to an individual, you may not be able to provide that information because it's, trade secret or confidential in another nature. So we do have to apply a little bit more scrutiny around this data than we did have to for consumers. And then conflicting obligations with California employment laws. This is a big unknown. If we can go to the next slide. So really, we don't really know where CPRA is going to fall in terms of, will it supersede the California employment laws, or if there's going to be, if California employment laws will take precedence, right? In context of employees, there's going to be a lot of challenges around, emails, any sort of like paper documents that we have, et cetera, that can be really challenging to try and provide back from a DSAR perspective and to vet them in a reasonable manner, right? It takes a lot of manpower to go through that kind of stuff, and it can be really, really challenging. We're expecting that the California Privacy Authority is going to have to, try and balance these, right? We're going to expect to see them make some concessions here and there to try to make this reasonable on the business without, infringing on the rights of the individuals that they were trying to instill. So I don't think anything is set in stone here, but just be prepared that you may have to make some judgment calls based on that. Next slide. So what do companies need to start doing today? The first real big one is you got to start inventorying your data, right? And ideally, you would have done a lot of this for your consumer rights already. However, when it comes to employees, again, there's probably new systems, there's new business processes and scope. You're gonna have to go talk to HR. And that's gonna be probably a difficult conversation with HR departments. If they haven't gone through a digital transformation yet, they most likely aren't really familiar with thinking of their processes as, traditional privacy processes that we're used to outlining. So there's going to be a little bit of education that has to go on there, get them to think through, exactly all of the systems that are involved, where they're collecting data, where they're storing it at, how they're using it. And, there's all kinds of, pitfalls that might pop up, right? What if you have, wellness programs, right, that you internally run, right, that aren't part of your healthcare plan? Those can be a little bit tricky. If you have any sort of employee incentive programs that, maybe do track purchasing or anything like that, those can be a little bit tricky to handle as well. You do want to make sure that you're really clear about if you are selling or sharing personal information, that you know where that data is going, and that you're giving your employees the rights to opt out where applicable, right? Now, there's some places where you just, we need this in order to fulfill an obligation with you. But if you are using it for any purposes, in a strange way, you'll certainly need to provide your employees the opportunity to opt out. You're going to have to update all your contracts, right? To make sure that any of your downstream service providers for employee benefits and all that sort of stuff are ready to support you. There is a little bit of a carve out around HIPAA data that we're expecting to see, but I would still be prepared to make sure you have those accounted for. Your privacy policies obviously need to be updated, ready to go. Those are going to be tricky. And then the workflows for actually fulfilling these are going to be probably the biggest uplift that you're going to have. There's a lot of considerations that need to be given around the sensitivity of the information for employees. You may not want to share your employee data with your privacy team, right? Your HR team may want to take the lead on that. You most definitely want to have a legal professional look over your responses before you send them back out. I know a lot of companies didn't do this with their consumer data because they figured it was pretty limited. But with employee data, there's a much higher concern that maybe they're looking to use this information for, they're probably a disgruntled employee, right? They're looking to see how they can use this data to their advantage. Maybe they're getting ready to file a complaint or a lawsuit against you. So you will have challenges around legal holds that you need to consider. You will have challenges around, is this data going to violate somebody else's privacy rights by disclosing it? What can be inferred from it? So definitely want to have a legal professional look over it all. And then finally, your DSAR portal, right? So there's even just operationally within the DSAR portal, there's going to be considerations around how do we secure the data? How do we make sure that the right groups have access to it? Do we have our workflows built into that portal? And do we have our website, our methods of intake updated to fulfill those contracts as necessary? Next slide. Of course, WireWheel has a full service offering to support you around this. We have our traditional employee subject rights fulfillment as part of our DSAR package. We do offer a full suite of data governance around data inventories, data mapping that we can support you around. We can help you manage your privacy policies. We can help you conduct PIAs and do high risk processing impacts. And we're launching our new universal preference and consent tool. And we have a brand new CPRA readiness assessment that you can take today, and we'll provide you with a quick assessment report afterwards that will give you some initial next steps to make sure you're ready for CPRA. Rick, back to you.
Yeah, great. Thank you, Sheridan. We had two additional questions in the Q&A, and they're kind of on the same page. Sheridan, we talked a little bit about the need to involve HR and legal and what's going to be in scope and out of scope. The questions are, one, how does this apply to video? And I'll ask the second question as well. There's a conflict with AML rules surrounding suspicious activity reports, whereby the disclosure is strictly prohibited and illegal. How can this be resolved? I'll take the first one with how does it apply to video? Typically, the video is going to be part of your agreement, your employment agreement with the company that you work for. And so my gut is that is going to be in the rock, paper, scissors continuum, the one that will surpass the others because it's your employment contract, but we'll need to see what happens with video stuff. Sheridan, I'll let you, you probably have some deeper knowledge on the second question in terms of suspicious activity reports or disclosures or anything that would be considered prohibited or illegal.
Yeah, if you can't disclose it because of another law or something like that, then you do not need to disclose it, right? You would need to provide somebody with a you need, this could obviously be careful, right? If disclosing that you cannot disclose data because of suspicion of illegal activity or something of that nature would be damaging, then you would document that internally. But yes, you would want to provide a reasons for why you couldn't provide some data, and so you would exclude it then.
Yeah.
In terms of,
yep, go ahead, Chairman.
I see the last one there. Is there a similar requirement for other new privacy regulations in other states? At the moment, most of the states have carved it out, I think. Is that right, Rick?
Yeah, I'm just double checking my notes right now. I don't think that any of the other states right now have included employee data as being in scope of their laws.
I'm pretty sure most of the states put a carve out in it. And the discussion for that was really to see how it goes in California, right?
Yeah.
Most people are waiting to see, does it work? And what are the pitfalls before they try and enshrine it into law themselves and then have to face changing regulations. So
yeah, what I would say is the common denominator between states, and it differs on how they talk about it, but they are referring to the exemptions more based on, are there federal exemptions for things like HIPAA or Gramm-Leach-Bliley or FERPA or anything in that realm? Yeah,
I think it is an important conversation point, though. Many companies are struggling with, yes, this is being offered in California, but if I don't offer it to my employees in other states, does that create some sort of unfair treatment, or is it going to exclude certain people? And so I think many companies are weighing whether they will offer it to all of their employees, right, as a way to just keep the playing field level and make sure that there's no issues there.
Yeah. Great. So again, this is our question slide. I think there are no more questions in the chat. Are there any other hand raisers as we think about wrapping up this presentation today? Judy, I will pass the ball back
Oh,
to
got
you.
another one. We got one last one. Going
Uh,
back to not having to disclose information that is part of a fraud investigation, do we still have to tell the employee that there's information that we cannot disclose, or can we omit it completely?
yeah, I think that the responsible response is a better way to say that would be, the way in which we will help you facilitate those requests, will accommodate this, is to respond back to your employee saying, we got your request, we can't fulfill it because, and here's what else you can do about it in the meantime.
Thanks. Thanks, Rick and Sheridan. We really appreciate it. If any of you have any questions going forward, please feel free to reach out to us. Oh, we have another question. This is a good question. Actually, and to confirm, these requests should be fulfilled by HR, correct?
I'll take that. So many companies are going to choose to have HR managing these requests. They don't have to be, but right. I think that there's quite a bit of sensitive data that will be exposed as part of these that you're going to uncover. And in my mind, it makes the most sense, right, to have an HR professional involved in that process, shepherding it forward.
My recommendation would be is that you have a discussion with your legal team, your privacy team, and your HR team. Under your, if you don't have one, create one, but under your data classification policy, create a data classification for employees, and then create the governance rules around that on how stuff is going to get handled.
And to follow on to that, yes, if your HR team is going to be involved in processing your DSAR requests, they absolutely need to receive specialized training specific to the role that they will be fulfilling in that process.
Yep.
Okay,
Judy,
great.
back to you to wrap it up.
Yeah, thanks everyone for all these fantastic questions. Rick, can you go back just one slide? So as Sheridan mentioned, we have a CPRA readiness assessment. Anyone who wants to take it, I'm going to put the link in the chat. We'll also send you the link as part of follow-up from the report. If you fill out the assessment, you'll receive a summary of responses, and Rick or Sheridan will reach out to you to talk you through the responses and see if you want to set up a time to talk through the responses. So again, the link is in the chat, or we'll also email it to you. Also, I wanted to talk through a couple of events that we have coming up. Anyone who wants to be at the IAPP Privacy Security, anyone who's going to the Privacy Security Risk Conference next week, Sheridan will be there and would be happy to meet with any of you. You can fill out a form on our website or just email Sheridan directly. We also have on October 27th, a webinar on Do Not Sell and why you should care. Again, you can register on our website. We're going to talk about the recent case where Sephora was agreed to pay over $1 million, what that means for CCPA and CPRA, and how you should be thinking about that. So please join us on October 27th. And then lastly, we have a WireWheel hosts a biannual virtual privacy technology conference. Our next one is going to be on December 14th and 15th. We're going to cover all kinds of topics, including this one and CPRA and what you need to know for CPRA, marketing, advertising, a wide variety of topics, and we would encourage you to register. Again, you can register on our website. Thank you so much for being such a great audience and giving us such great questions. And thank you, Rick and Sheridan, for participating.
Yes, I reiterate all of that. Thank you, Sheridan and Judy, for helping pull this together. And thank you to all of you for your participation.
Yes, thank you so much. This was great.